Assalamu alaikum wa rahmatullah. Welcome, dear listeners. You're tuned in to Inspire FM 105.1 FM, and you are listening to today's episode of the Ask Your Lawyer show. I am your host, Usama, and today we'll be talking about legal disputes, different types, and how to go about resolving them. Please note that any information discussed today does not constitute legal advice, and your matter, or should you require specific advice, you will need to obtain specific legal advice for your given situation, and the information discussed today is for information purposes only. So there are many different types of disputes that can arise between people, or to use the legal term, between different parties. They can arise in many different contexts. Disputes can arise in the commercial context between two companies that have done business together. They can arise between a landlord and their tenant. They can arise between the employer and the employee. Disputes can arise in all types of different commercial arrangements. How those disputes are navigated and how they're dealt with in the UK legal system varies depending on, number one, the type of dispute that it is, and number two, the value of that dispute. So in the UK, we have different systems and processes for different types of money claims. So let's talk about money claims first, which is probably the most common type of dispute. Normally, when two parties have a commercial dispute, when they've been involved in a business relationship or something of that like, the issue tends to come down to some sort of financial discrepancy. The first step is always to try to resolve that dispute without sort of any legal action or any type of escalation. The first step is always to try to amicably resolve it, and that's always the sort of best advice that you can be given initially. And only where you've tried to take those efforts to no avail and you're not able to resolve it, should you look and consider your options from a legal perspective. So, depending on the value of the claim, that will determine the course of action to take next. Typically, you have sort of three broad categories. You have a small money claim, you have an intermediate money claim, and then you have sort of a high value, large money claim. Typically, a small money claim is generally a claim where the value is £5,000 or below. That's typically the value of a small money claim. And generally speaking, the process is quite straightforward. There is a system called Money Claims Online, or MCOL, where you can register to set up an account and you can sort of engage in a legal process through that. And it's a step-by-step process, and it's designed for the litigant in person, or the person that's representing themselves, not legally represented. If you're legally represented, then obviously your lawyer will take care of this process for you and advise you on the appropriate step. If your claim is worth more than £5,000, then the process is a little bit more complicated, and it may be a little bit more costly. But you should always consider the commercial viability of taking your case to a legal process, taking it to court or not. That should always be at the forefront of your mind when considering to take legal action against anybody. Is this worth, commercially, the time, effort, resource, and cost of taking legal action or not? This is a key consideration. So before going down a sort of legal route and issuing any proceedings or anything like that, should first try to resolve the matter, amicably yourself, through communications, through setting out your issues, etc. And if all else fails, then you should send a letter before action to your opposing party, to the defendant. And that letter before action has to set out what it is you're claiming, what the basis is, if there was some business that went between two parties, if there was some sort of agreement in place, a written contract, then the details of that written contract need to be referred to and explained, and the terms which you're relying on that were breached need to be set out and made clear to the opposing party. And then that will sort of set out the grounds for your claim and the process moving forward. It's a formal action that's provided, that's sent to the other side, that you would be relying on in any future proceedings. So if you are going to issue a claim in the courts, then you would be showing the courts that you had taken efforts to resolve the matter by sending a letter before claim and inviting the other side to pay what's owed. But what's critical is that you weigh up the grounds that you have, and the best course of action is to take legal advice on your specific situation, because every situation is different. But hopefully you'll have a contract in place, and the terms of that contract are clear and in writing, and you know exactly what it is you're seeking to rely on. And you can bring that to the attention of the other side through your letter before action, and you can set out your claim and the contract that you rely on. Where there's no written agreement, then matters become a little bit more complicated. Now, under English law, there isn't actually an obligation to have your agreement in writing. You can have a valid contract, which is verbal, but the issues with that are quite obvious. It becomes, a case of where things go wrong. It becomes a case of, he said, she said, and what was the actual terms of the agreement, what was actually agreed between the parties. It becomes very difficult to prove. And then you have to rely on sort of supplementary evidence like communications, maybe messages, maybe conversations. Maybe you don't have anything at all in writing, and you have to simply rely on the witness evidence or your version of events. And this is a common problem that in the legal profession we see, where parties engage in commercial arrangements. They do business together, they employ people, they enter into business partnerships and arrangements, and they do so without creating any formal document, without any legal contract in place. And the response when asked why, people tend to look on the bright side more so than anything else, and they don't really think or imagine that anything is going to go wrong. And unfortunately, that is very rarely the case. And people can sometimes think that they have a personal relationship. The parties are friends. They've known each other for a long time. Maybe they're even family. Whatever it might be, for whatever reason, they think that there's no need to enter into a written agreement because we have this personal relationship and nothing's going to go wrong and whatnot. And, we hear it all the time. But unfortunately, nothing goes wrong until it actually does. And that's why it's always advisable to ensure that your agreements are in writing and, they follow a sort of formal structure. And there is, something substantial in writing between the parties setting out the key terms of the agreement. Because when something goes wrong, you've got something to refer to. Everybody's obligations, everybody's responsibilities are set out, they're clear, they're in writing, and the parties know what they're doing. And if it's a case of, well, you haven't paid me on time, or you owe me this much money, or you said you were going to do this, then the parties can rely on the written contract to set out exactly what their obligations are. And it can clean up a dispute a lot more quickly and a lot more easily. When there's nothing in writing, then it's a case of trying to create or build your argument based off of, other forms of evidence, which you may not even have. And then it simply becomes your version of events, your witness evidence, which will normally invite scrutiny by the other side, particularly if the dispute goes to the court system, and you find yourself in a hearing, and you find yourself being cross-examined by a barrister representing the other side, who's really quizzing and digging into your version of events and looking for holes. All that because there's no written agreement to go by. So it's always advisable to have a contract, a written agreement setting out exactly what's what, and that will save you a lot of time, headache, and cost in the future. So if you've sent your letter before action and there's been no sort of response, or you're not getting anywhere, your claim is still valid, you haven't been paid, whatever it is, you haven't come to any agreement, then you need to consider how best to move forward. You need to consider whether or not you want to escalate this matter by taking a matter to the next step, i.e., the legal process. If you've weighed it up, and let's just run through what the cost of doing so is. Now, remember that you have different sets of fees when it comes to bringing a claim. You have to pay, if you're taking a claim to court, you're actually issuing it within court, then that will attract a court fee. You'll need to pay a fee to the court for filing and processing your claim. That excludes the lawyer's fees. The lawyers will charge you for the work that they do, the time that they spend preparing your claim, giving you advice, preparing the documentation, etc. The courts, they will have their own fee. And the fee that the court charges for a claim for money specifically, it varies, but it generally depends on the amount of the claim value. Yeah. So if you're talking about a lowish value claim, as we said, under the £5,000 mark, then you're normally paying a fixed fee based on a percentage of the value. So if it's up to £300, the court fee is £35. If it's £300 to £500, it's £50. If it's £500 to £1,000, it's £70. If it's £1,000 to £1,500, it's £80. If it's £1,500 to £3,000, it's £115. If it's £3,000 to £5,000, it's £205. If it's £5,000 to £10,000, it's £455. And if your claim is above the threshold of £10,000, i.e. the value, the money that you're claiming is above £10,000, but less than £200,000, it is the court fee is 5% of the claim. So depending on the amount of money that you're claiming, you need to consider what the court fee is going to be. And the court fee is separate to the fees that the lawyers will charge you for advising, preparing, drafting, etc. So the first thing you need to value is the commercial viability of the claim that you're bringing. It's a live show today, so if you have any questions, you can call or text 01582 481822 is the number to call. And if you want to text, the number is 0779 481822. I should say WhatsApp as well. You can WhatsApp 0779 481822. So feel free to give me a ring and we can have a chat about your legal queries, particularly around money claims. So you have to weigh up the commercial viability of your claim. Now, generally speaking, under English law, there is the principle that the winning party is able to recover their costs, or the losing party pays the costs of the winning party. So if your claim is successful, then generally speaking, you will be able to recover the amount of money, a portion, I should say, of the amount of money that you spent in pursuing the claim. You will very rarely, if ever, recover 100% of your costs, but generally the average amount is between 60 and 70% of the cost you'll recover. Now, when it comes to smaller claims or lower value claims generally under £100,000, they have what came into force in October of last year, a fixed costs regime. So the amount that you can recover for those claims will be fixed to a certain amount. That's the amount that can be recovered on them. So that's also something to bear in mind. So in essence, if you're looking to bring a claim for money, you have to make sure that it makes commercial sense. Weigh up the time, the effort, and the cost of actually pursuing the claim versus, the likelihood of success and, the likelihood of cost recovery as well. So your first step would be to issue a letter before claim and give the other side, generally speaking, 14 days to respond. If they don't respond, then you can generally bring your claim in the courts. And if it's a claim for money, then the appropriate court to bring such a claim is the county court. The county court. Typically, if the claim is less than £10,000, then that claim would be assigned to the small claims track, which is a more simplified process and less costly, designed for more straightforward claims. If the amount is over £10,000, then it gets assigned to a different track, and the process becomes a little bit more complicated and specialist. You should also consider whether or not there's any time limit for you to recover the money that you're owed. So if you are bringing a claim for money for a breach of contract, whether it's a written or a verbal contract, that's not relevant. But the period for you to be able to bring the claim is 6 years. Yeah, this is a general rule. There are certain exceptions. There are limited exceptions. But the general rule is that you should bring your claim within the statutory limitation period, which is six years. So if you're owed money and you're coming close to the 6-year anniversary, then you need to take action fairly soon, because you may run out of time, and then your claim will be statute barred. It will be statute barred. So always consider the time limit when thinking about bringing a claim. And as I said, if it's a simple, straightforward claim, you can use the MCOL system, the money claim online. And again, that's normally for people that aren't represented by lawyers. If you're represented by lawyers, then they will normally do it with the actual court itself. You'll need to fill out the details of your claim, complete a claim form, and you'll need to pay the court fee. As I said, that varies depending on the value of the claim, how much you're claiming. And then once that has been submitted to the court will then process it, and they will send a copy of your claim to the other side, who will be referred to as the defendant in the court proceedings. And you might be on the other side. You might be someone that's received a claim form. Someone's trying to claim money from you. What do you need to do in that case? Well, if it's a court document, if it's a court sort of sealed claim form that's been sent to you by the court, then you need to take action. I would strongly advise that you don't just leave it there and hope it goes away, because generally it won't. And if you don't respond to it, if you don't respond to the claim form, then the person bringing the claim, the claimant, will have the option to ask the court to make a judgment in default, which basically means that the court will make a judgment in the claimant's favor in default, because you haven't responded, or you haven't attended, or you haven't followed the process and filed the correct paperwork. If you fail to do that, then the court has the power to issue a judgment in default, and that will be in favor of the claimant. Then what can the claimant do with a judgment in default? They have a court-approved judgment. They can go and get that enforced. That can be enforced by county court officers, bailiffs, and they can come to your property, potentially seize your assets. If you own assets, they can look to take those assets off you, seize them, or if your assets are property and things like that, they can potentially put a charge over that property. So it's very important to respond to a claim form if you are in the unfortunate position of receiving one. And what would be the best thing to do is get yourself some competent legal advice. If you receive the claim form, then your options are essentially to pay the claim form, pay the claim amount in full if you don't dispute it, if you think there's no real way to dispute this and the money's owed, in which case you would just then pay the fee and end it there. Or you can defend the claim. If you consider that there is a valid defense, then you can look to defend that claim, in which case you'll have to file a defense with the court and send it to the other side. And that normally has to be done within a specific time period. Remember, if you don't do the process or don't file the documents within the requisite time period, then the claimant can potentially apply for a judgment in default against you. So it's very important to follow and stick to the court prescribed time periods. So you will normally have two options if you receive this in terms of responding. You can either file your defense within the 14-day prescribed period, or you can file an acknowledgement of service, which will then give you a further 14 days, i.e. 28 days in total, to provide your response. So if you need more time to consider the claim against you, to get legal advice, to look over the issues, etc., then you can file an acknowledgement of service, in which case you will have a further 14 days to provide your response. And that's the sort of initial process that's carried out. And if you do file a defense, or if the defendant files a defense, then the court will look at both sides of the claim, the claimant side and the defendant side, and they will decide what the next steps are. They will decide if the matter should be assigned to a higher track, the intermediate track, the fast track, or the small claims track. Normally that's to do with the value, but also the complexity of the case will also play a part in that decision. And depending on the track that the case is allocated to, the process will vary, and the complexity will vary, and the level of time and input will vary. The court will then normally tell the parties that you have to comply with certain directions. They will set like a series of events up until the final sort of hearing date, which are various steps involved. One of the most important steps is the disclosure stage, which is where the parties will be able to disclose documents and information relating to the case, and that will form a significant part of the evidence used at any hearing. The disclosure stage is probably the most complicated, time-consuming, and costly part of the process. And eventually, once all those stages are complied with, you will, if the matter is not settled, and we'll come on to talk settlement shortly, you will find yourself in a hearing in front of a judge and given the opportunity to plead your case. That's whether you're the claimant or the defendant. Either way, you will have the opportunity to plead your case. And the judge will consider the arguments of both sides. If you're legally represented, then your lawyer will advise you of the process. Your lawyer will take care of all of the preparation for the hearing. Your lawyer will represent on your behalf and speak to the judge and make the submissions on your behalf. And the judge will hear the arguments from both sides, ask what he or she needs to ask, and depending on the complexity of the case, how many witnesses are brought forward, and etc., it could go on for days, but normally on a simple money claim, it can be done, in a fairly brief hearing over the course of a few hours, and the judge will issue their judgment, on the day or maybe at some time later. And the judge will normally, find in favor of whichever party that they consider to be correct in the circumstances, and then they will hand down their judgment. So the judgment will be handed down. If it's in favor of the claimant, then the judge will normally award them, the damages, the payment that's due to them that they claimed. If it's in favor of the defendant on a money claim, then normally they will be telling the claimant that the claim is not valid for whatever reason and that no payment is due. And if it's a money claim, it's relatively straightforward. The judgment is either, whether the payment is due or not, or part of it is due, or depending on the facts of the case. Now, the next aspect that's dealt with by the judge is the question of costs. If the case has gotten all the way to a hearing, and normally that process will take at least a year, normally 18 months with the current backlog. But if that process has gone, for all the way to a hearing, then both parties, the claimant and the defendant, will normally have incurred, if they're legally represented, will normally have incurred a significant amount of costs, because all that process would have been carried out by the lawyers, etc. So if the payment has been awarded, then the defendant will be told you've got to pay this money within this period of time, etc. And we'll come on to what the claimant can do with that judgment shortly. But let me just tackle the question of costs. So both parties, if they're legally represented, would have incurred significant legal costs getting to this stage of the hearing. So they will want to recover it. And as I said before, the general rule in the English legal system is that the the losing party or the unsuccessful party will pay the successful party's costs. So what will happen is the lawyers will prepare a bill of their costs, setting out what their fees were. Also, the court fee will be included in there, any other costs, etc. And then that will be sort of given to the judge, and the judge will make an assessment on those costs. And typically, the judge will award, costs between 60 and 70%. Obviously, if the costs are not sort of accurate, they're considered to be inflated or whatever, then it could be less. But generally speaking, you won't get 100% of your costs back. You're likely to recover in the region of 60 to 70%. And that will be payable on top of whatever the claim award is. Going on to an ad break now, so I will see you back in the next part of the show. Thank you very much for listening.
This program will continue after the break. Continue listening to Inspire FM. Inspire FM.
Inspire 105.1 FM.
स्टूडेंट कम्युनिटी की आवाज, आपका अपना रेडियो स्टेशन इंस्पायर एफएम।
Luton's most luxurious venue for Asian weddings is now bigger and better than ever before. With 2 venues to choose from, Venue Central can provide the ultimate setting for your wedding. 2 huge venues, 1 high standard, right in the centre of Luton. Visit us online today at venuecentral.co.uk or call us now on 01582 451 767. Venue Central, affordable luxury in a central location.
Did you see that guy on TV?
What, that no comment guy?
Yeah, he was sick. What was his name?
I think it was Atiq Malik.
Yeah, Atiq Malik of Liberty Law Solicitors. Atiq Malik heads up the criminal law team at Liberty Law Solicitors, specialising in everything from serious crime down to road traffic offences.
To find out more or for a free telephone consultation, call 01582 459955.
Liberty Law, there when you need us most.
They listen to Inspire FM 105.1.
Inspire FM is looking for committed, talented and knowledgeable individuals to join the Inspire Academy as tutors. We're looking for tutors who can teach maths, English, science and IT to join our pool of tutors and run face-to-face sessions on weekdays. To apply or for more information, email rashid@inspirefm.org or call us on 01582 481810.
Since October 2023, Gaza faces unprecedented challenges. Muslim charity dedicated to Gaza for a decade steps up in trying times. Clean water, hot meals and vital medical aid. Your support can deliver hope. £50 for emergency food, £70 for 20 meals, £150 for clean water and £200 for essential medical aid. Unite at muslimcharity.org.uk/Gaza or call 03000 111 786.
Allah says, I have created you in different nations and different tribes. In other verses, he's saying different languages and different colors. Lita'arafu, so you will know people, understand people, learn to live better with people. Lita'arafu, not detest people, not hate people, not kill people. We are supposed to be the people who preach love and peace and the oneness of God and unite people. And whether people understand or not, our job is to give the message.
1 in 4 people suffer from mental health issues.
But in our community, it's a taboo.
लोग क्या कहेंगे? ये तो साड़ी बेइज्जती है.
Is Allah subhanahu wa ta'ala punishing me?
क्या मेरे पर किसी ने जादू कर दिया है?
Let's break down some barriers and start talking about it.
Join us on Mindful Moments on Fridays at 5 p.m. to learn about how we can support our mental well-being.
Mindful Moments. Let's give our minds the attention it deserves.
From the studios of Inspire FM, the time is now 7:30.
Assalamu alaikum. Welcome back to tonight's edition of the Ask Your Lawyer show. I am your host, Usama, and today we're talking about disputes. We talked in the first half of the show about the process for bringing a claim in the courts in the UK for money, for outstanding money, and we talked about the pre-action steps that you need to take, that you should issue a letter of claim, that you should set out your arguments clearly, that you should weigh up the commercial viability, the costs associated with bringing your claim, and all these different things before actually embarking on issuing a claim. To get legal advice at the earliest opportunity is always a good thing to do. It will save you a lot of hassle and stress and cost in the long run. And it's also advisable. It may be too late for this if you're considering a claim, but it's always advisable initially to have your agreements in writing, to follow proper process and get things done formally, because it'll save a lot of issues down the line. So we talked about the hearing and when the judgment is handed down, and we just sort of finished talking about the cost situation and how that works, and the recovery of the costs, etc. So if for example you are the claimant, you've brought your claim, you've gone through the hassle of a court hearing, you followed the process, you've hopefully instructed lawyers that have dealt with it for you, and you are now very pleased because you've got a judgment in your favor. The court has given you a judgment in your favor, telling you that this defendant, this old business partner of yours, this old business contact of yours, this maybe relative of yours or friend of yours, whatever it is, owes you some money, hasn't paid you, has been difficult, has forced you to go down the court proceedings route. You've lost a year and a half of your life to this court process. You spent a lot of money, had to deal with maybe a very pleasant lawyer such as myself, maybe a not so pleasant lawyer like somebody else. And that process has really caused you a lot of grief. And now you're thankfully sitting with a court judgment in your favor. What do you do with that? Well, the court will normally tell the claimant that they have to pay whatever's due, whatever the court has awarded, within a certain time period. Normally within 14 days, typically what they'll say. And if they don't make the payment, then what do you do? Well, what can you do? Now, something to always consider before taking any action, is, does this other party have the capacity to pay me? Are they going to be able to cover this amount of money? Because, there's a concept that we often hear and use, that there's no point throwing good money after bad, right? So if the other party owes you money, clearly there's no real defense to their to the arguments that you're making, and it's a clear-cut win. They owe you the money. It's in writing. It's been breached, and there's no real dispute around it that they can. There's no defense that they can realistically, practically bring. If you're going to take legal action, you want to satisfy yourself that this defendant or this other side, this other party, has the capacity to pay you. Because otherwise, you'll be issuing a claim, you'll be spending a lot of money, you'll be losing a lot of time, and maybe growing a few more white hairs, and that will cause you a lot of grief. And if they haven't got the money to pay you at the end of it, then how useful is that judgment in your favor? So you have to weigh up and consider the actual likelihood of you recovering any money, even if you've got a good case. Yeah, even if you've got a good case, if they can't pay you the money, then you'll be spending good money after bad, trying to recover something that can't be recovered. Or another way is to assess a person's assets. If they've got significant assets in their name, then normally you can, with a judgment, you can pursue their assets. So you've got this judgment in your hand, and now you can request enforcement of that judgment, i.e. you can ask the court to send bailiffs to recover the debt for you. That might mean bailiffs attending a person's home, a person's business, whatever it might be, and they can seek to recover the money that way, and if not, bailiffs have the authority to recover assets. Another thing you could do with the judgment, if the other side isn't playing ball, if they're not cooperating, if they're not paying their dues after the court has ordered that they should do so, is you can get an attachment of earnings order. An attachment of earnings order, which is essentially it is a direct deduction from a person's salary. A direct deduction from a person's salary. So what you could do is you could make an application, and the employer, the company that that the defendant works for, if they're an employee, presumably, obviously, if you're dealing with a company and it's a commercial dispute between business to business, then attachment of earnings order wouldn't necessarily apply. There are other options which we'll discuss. So an attachment of earnings order is where the employer of the defendant, the person that you've got the judgment against, has to, by law, by order of the court, deduct a portion of the person's wages to pay you back. Now, if the person doesn't earn a lot of money and the debt is quite large, then it may not be a massive amount, and it may take a long time for that money to be paid off, but it's still recourse and a way of recovering your money. So the courts can send bailiffs, you can get attachment of earnings order. What else can you do with the judgment? You can obtain a charging order, which is securing the debt against the person's property. That is, if they own any real estate. So if the person owns property in their name, then you may be able to apply to the court for a charging order against them, which means that you will have a registered charge over that person's property. And in some cases, you can ask the court for an order for sale. In other words, you can ask the court to force the defendant who you have a judgment against to force them to sell that property so that you can recover your money. Now, an order for sale is a specific sort of application that's made. It has its own rules, but one thing to consider generally is that if the person only owns, a single property and it's their dwelling home, somewhere where they live and reside, and if they have a family and the children are living there, etc., and they don't have any other property, then it's probably unlikely. Obviously, every case turns on its own individual facts. This isn't specific legal advice. This is general information on the law. If the person has a family or children, etc., living at that residence, and it's the only property that they have, then in most cases it will be very difficult for you to obtain an order for sale. You could get a charge on the property, but an order for sale would probably be difficult in those circumstances. If it's a secondary property or a rental property, a buy-to-let, etc., where the person has multiple properties, then an order for sale is normally a lot easier to get in those circumstances. So you have to weigh these things up from the outset and not jump into anything. Now, an order for sale, if you can't get an order for sale but you've got a charging order, that means you register your charge on the property, and anyone who wants to buy that property will see that charge. And if the person does sell that property at any stage, then you can look to enforce your charge and get paid your debt. Obviously, that might be a very long time, if at all. So, the value of a charging order has to be considered in each individual circumstance. So these are different sort of things that you can do when it comes to a court judgment. If your judgment is against a limited company, then you can always still send bailiffs to that limited company's offices, and they can sort of pressure them to make payment. and they can seize assets, etc. If the company owns assets, whether that's property, whatever it might be, any type of asset, then if it's owned, provided it's owned by the company that you have a judgment against, then you can look to recover those assets. Now, sometimes when it comes to limited companies, because in English law we have this concept of limited liability, and what's referred to in law is as the corporate veil. So if companies in the UK, they have separate legal personality. What do we mean by that? So essentially, a company is treated as an independent sort of entity or person for the purposes of law. A limited company, that is. So if you have a limited company, you have directors of a company who are responsible for the day-to-day management and operations, and you have shareholders, the people that own the shares in that company. However, the company itself is treated as its own, as a separate person in law. So that company can enter into contracts with other parties. That company can enter into agreements, can take out loans, can take out credit, can take court action, etc. It's treated as its own independent personality. So what does that mean in the context of disputes and claims? If your claim is against a company, so for example, say you've done some work for a company and that company is due to pay you money, and for whatever reason they haven't, and a dispute arises and you're looking to recover your money from that company. Let's say, for example, you've got a contract in place and the contract terms are clear and the obligations have been breached, and you've got a good case. In that instance, you need to bring your claim against the company because that's the party that entered into the contract with you, not the directors of the company personally, not the shareholders personally. Your claim would need to be against the company itself. Now, companies have their own legal personality, which means that the company will be liable for any outstanding payments, any breaches of contract, etc. It will be the company itself that will be liable, and not the shareholders or the directors necessarily. So if the company can't afford to pay its debts, then the company can be wound up, and then whatever assets or funds the company has will be distributed amongst however many creditors that company has got. If the company's got loads of creditors, i.e. it owes a lot of different companies and banks and people money, then there will be whatever that company has in terms of assets or funds will be distributed across those different creditors. And depending on what type of creditor they are, they will hold a higher position in the order of priority when it comes to payments. So if you're bringing a claim against the company, you have to be conscious of that company's financial standing. If the company is struggling, and the good thing about UK companies is they have to publish a lot of information publicly. You can find most information that you need about a company on Companies House. They have to file annual accounts, which are published. They have to file confirmation statements, which are published. So before issuing a claim or taking legal action against the company, it's always advisable to assess the financial standing of that company and to assess if it's got any charges on it, if it's got any debentures, if it's got any assets. By looking at the balance sheet, you can weigh up and you can have a good idea of the standing of a company by looking and assessing the publicly available information on Companies House. So before issuing a claim, you want to look at that. You want to establish whether or not the company is good for payment. And if it is, then if the company has got value, if it's got goodwill, if the company is a trading company, it's a well-known company, it's got contracts, the company can't just be wound up. It won't want to be wound up because it's got trading history, it's got a relationship, it's probably making money, it's probably got assets. So it won't want to be wound up. If it's a smaller company, doesn't have much traction, doesn't have much assets, etc., maybe has some money in the bank, maybe has some smaller assets on the balance sheet, then you want to consider carefully whether or not issuing a claim against that company is worth it. Because if that company gets wound up, then generally speaking, and the company doesn't have the money to pay, then it kind of just ends there. And there's not much else you can do. The company can't pay. You can't really go after the directors or shareholders of the company because the company has its own legal personality. And if the company is who you entered into a contract with, then that's who you can go after, not the directors or shareholder, unless there has been wrongful trading or fraudulent behavior on the part of the company directors or shareholders. If they have maybe made payments where they shouldn't have, maybe they have dissipated the company's assets with knowledge that a claim is coming. If they suspect that a claim is coming, and then because of that reason, they have sort of, disposed of the company assets, at value that's below value, etc., then you could bring a claim against the directors of the company for potentially fraudulent conduct and failure to comply with their obligations under the Companies Act. So that could be another option. But if the company genuinely can't afford to pay, doesn't have the money, then your recourse will be limited in those circumstances. So always consider the viability of the other party to pay. And that's why in a lot of cases you have companies who are dealing with other companies. They may ask for a guarantor, which generally means that you're bringing a third party into the contract to basically guarantee that, whatever obligations are going to be met. Yeah, the third party will sort of guarantee that. So let's talk a little bit about guarantors. It comes up in different types of contexts. One of the most common uses of guarantors is in the property context. So if a person is taking on a commercial lease, for example, and if you're a landlord and you're issuing a commercial lease to a tenant, and it's a company, you're renting out a shop that you own the freehold for, and your tenant is a business, i.e. a limited company. If that's the case, you might want to consider, especially if that company doesn't have any assets, doesn't have a long trading history, hasn't been incorporated very long, etc., hasn't got much showing on the balance sheet, then you might want to consider getting the company to provide a guarantor, which is ideally a person, an individual, rather than another company. And what that means is that if you're if in the event that there's a dispute, in the event that the tenant fails to pay rent, which is quite a common issue that happens, and the landlord wants to either take the limited company to court or terminate the lease or whatever they want to do, you've got a guarantor behind it. If the company can't afford to maintain its business, it gets into financial trouble, and it's no longer sort of solvent, and it gets wound up. If there's no guarantor, then you as the landlord will have very limited recourse. And if rent arrears have stacked up over a long period of time, your ability to recover that will be very, very limited. So it's always advisable in certain circumstances to obtain a guarantor. And how does that work in practice? Well, when you're agreeing the lease, which it has to, legally speaking, it should be done formally in writing with solicitors instructing, preparing the lease, etc. If that's been done, then you ask your solicitor who's preparing the lease that you want a guarantor to be put in place. And what that means is if in the event of any default, in the event of any breach by the landlord, by the tenant, then you have the ability to recover that from the guarantor. You have the ability to cover that from the guarantor themselves. Yeah. So it's always useful to get a guarantor because that person will have personal liability over the obligations of the tenant. Yeah, so that's one sort of way. Again, most of the time, prevention is the best cure. Getting these things done properly, getting a proper contract in place, weighing up the party that you're doing business with, putting in, special measures like putting a guarantor in, etc. These are things that you can do to protect yourself when entering into some sort of commercial transaction. And doing this initially is always more advisable and better than doing it. You can't do it retrospectively. If you haven't dealt with it properly, if you haven't formalized your contract and your agreements, then it will cost you a lot more money. It will complicate the matter, significantly, and it will make things very difficult for you. So it's always best to get things done properly, get legal input at the earliest opportunity, and do things in a proper manner. You will be very grateful that you did later if you find yourself in a dispute. I can assure you of that. Now, I just want to touch on one other common issue that I come across in my legal practice, and that is the expectation that claimants have. So sometimes people want to bring a claim against another party, business associate, whatever it might be, and they're very unhappy about the way that the business has been conducted, and payments are due, and whatever it might be, and they want to bring a claim for whatever it is. But what people often are sort of not content with, and I spend a lot of my time explaining this point, is that there is in English law, what you can recover is essentially the losses that you've suffered. Yeah, for a claim for money, for a commercial claim, generally speaking, you are able to recover the losses that you have suffered. Yeah, not the amount of headache that you've received and how upset you are, in the circumstances, etc. It doesn't matter how much grief that the other party has caused you. Generally speaking, in English law, you are entitled to damages for the losses that you've suffered. And what that means is you have to set out exactly what the losses are that you've suffered. Yep, this is what I've lost, and then you have to connect the losses that you've suffered to the other party. So you have to show clearly that this conduct by the other party, their failure to comply with their contractual obligations. So you have to establish what the obligations are. This is what they were obligated to do. Obviously, if there's a written agreement, it's a lot easier to do that because you can just cite the contract. This clause says that they have to do this, and they haven't done it. They're in breach. If there's no written agreement, then you have to try to prove what the agreement was. Yep, whatever it was, you have to try to prove it based off of different things, and then you have to show that they've breached it. So you'll have a much more complicated additional task in showing what the actual agreement between the parties was. Then you have to show that they breached it. And then you have to show the losses that you incurred as a result of that breach. Okay? And that is, generally speaking, what the courts will award if you're successful. They will, if the loss is sort of too remote, if it's if it's unreasonable, if it's excessive, if you could have easily prevented the loss, then the courts will consider that. So they will consider these things when issuing an award. But you have to remember that in the UK legal system, the court is not going to be too concerned, generally speaking, with how much, headache or stress or nuisance this person has caused you, how wound up you are about their conduct. You can't just pluck a number out of thin air and say, well, I want, this much money because they stressed me out this much. Generally speaking, it's, in a business dispute, a commercial arrangement, claim for money, it's based on the losses that you suffered. Yeah. What are the losses? How are the losses calculated? So there's a breach. Here's the contract. This is what we agreed to do. This is what was agreed between the parties. And this is the breach that person carried out. And as a result of that breach, there has to be a direct connection we call it causation in law. There's got to be a direct connection between the breach, the conduct of the other party, and the losses that you suffered. If you suffered a loss, if they breached the contract and you suffered a loss, but the loss was nothing to do with their breach, it was something completely independent of their conduct, then it will be very difficult for you to prove causation and very difficult for you to prove your losses in those circumstances. So, in summary, very important to document your arrangements, follow the correct process, get yourself some legal advice as early on as possible, and in the event of a dispute, you have to follow a specific process, consider the commercial viabilities of going ahead with the claim, and get legal advice at the earliest opportunity. If you need any advice on any debt issues, dispute, commercial disputes, etc., you can reach out to me. You can do so by contacting Inspire FM, who can share my details with you. And I would like to thank you all for listening, and hopefully we'll speak to you again on the next show. Thank you very much for listening.